One ordinary Tuesday afternoon, a 69-year-old woman in Tennessee did something she'd done countless times before. She logged in to check her bank account. Her name was Carol. She had always been responsible with money. Bills were paid on time. She kept extra funds in checking so she wouldn't get caught short. A couple of years earlier, when arthritis started making trips to the bank harder, she added her son to the account so he could help if needed. To Carol, it was a practical decision, a simple convenience. Then one morning, she looked at the balance and froze. $44,000 had disappeared. It hadn't been taken by some scammer halfway across the world. No hacker broke in. No stranger stole her identity. The money had been withdrawn legally by someone whose name was already on the account. When Carol called the bank, hoping there had been some mistake, she got an answer she never expected. There was nothing they could do. According to the agreement attached to the account, the other person had every legal right to take the money. And Carol's story is not unusual. Versions of this happen in families all over the country every year, and almost no one gets warned beforehand. People usually learn the truth only after the damage is done. I'm Lana Maines, and if you're new here, subscribe and turn on notifications right now. Every week on this channel, I break down the financial rules, protections, and changes that directly affect seniors. What's changed, what benefits you may already qualify for, and what practical steps actually protect your money. That's exactly what we're talking about today, so let's get into it. Because if you share a bank account with anyone, a spouse, a parent, an adult child, a brother or sister, there are 3 important rules tied to that account that have quietly shifted. No clear announcement, no big warning from your bank, no helpful conversation at the branch. Most people won't discover any of it until the consequences hit them personally. And there's a reason your bank is unlikely to bring this up on its own. Joint accounts are convenient for customers, but they're also efficient for banks. The money stays in the system, remains easy to access, stays insured, and continues generating fees and activity no matter which owner moves it. From the bank's point of view, there's very little reason to slow down the account opening process by explaining what equal ownership really means in legal terms. But that legal reality matters a lot. Shared account abuse and exploitation cost Americans billions of dollars every year. In most cases, the harm is not caused by strangers. It comes from someone the account holder already knew, trusted, and in many cases loved. And the losses are often devastating, not a few $100s, but tens of thousands. The problem starts with one basic misunderstanding. When you put someone on a joint account, you are not simply giving them permission to help. You are not naming a backup person. You are not creating an assistant role. You are making that person a legal co-owner. That means once both names are on the account, the bank generally treats each person as having equal and independent rights to the full balance. Not half. Not their portion. The full amount. Every dollar in the account can typically be accessed by either owner acting alone. That's the part people rarely hear clearly. At the bank counter, the explanation usually sounds harmless. If something happens to you, the other person can step in right away and pay bills or access funds without delay. And yes, that convenience is real. But what often goes unsaid is that the legal consequences begin immediately, not only in an emergency. A parent may add an adult child to help manage bills. A widow may add a son or daughter after a health scare. A spouse may add a sibling temporarily after surgery. In their mind, they are arranging support. Legally, they may have done something much bigger. They may have transferred full access and ownership rights. And that brings us to the first rule change you need to understand. Rule change number 1 is the survivorship issue, the clause that can override what your will says. This is the one that shocks families after a death, because many people assume a will controls everything. It doesn't. Most joint accounts in the U.S. are set up with what's called a right of survivorship. In plain English, that means when one owner dies, the money in the account automatically belongs to the surviving owner. It does not wait for probate. It does not get paused for review. It does not follow the instructions in the will first. The transfer happens automatically under the account structure itself. That principle has existed for a long time. What has changed is the way banks have strengthened and updated the language in account agreements, making it even harder to challenge later. In practice, this means the wording attached to the account can completely outrank what your estate documents say. Here's how this plays out. A parent has 3 grown children and leaves behind a will saying everything should be divided equally among the 3 of them. But years earlier, that parent added just 1 child to the bank account for convenience. When the parent dies, the money in that joint account usually goes straight to the 1 child whose name is on it, not 1/3, not split evenly, all of it. And the other siblings often have little or no practical way to recover their share, because the account agreement controls that asset directly. The will may say one thing, but the joint account says something else, and the account usually wins. That's the part many families never see coming. People often assume, well, my will explains what I want, so everything will be handled fairly. But a joint account can sidestep that entirely. If the account is set up with survivorship rights, the balance transfers outside the will. What makes this more dangerous is that many people haven't looked at their account paperwork in years. Some opened these accounts a decade ago. Some opened them even longer ago than that. But banks can update account agreements over time, and those updates may govern your account even if you never sat down and signed a brand new stack of papers in person. The notice may have been mailed, tucked inside a statement, or buried in fine print few people ever read. So the version of the agreement you think you have may not be the one controlling your money today. That's rule change number 1. Rule change number 2 is even more unsettling for many people, because no one has to die for this one to become a problem. It has to do with creditor access. Once someone becomes a co-owner of your joint account, their financial problems can start reaching toward your money. And that catches people completely off guard, because emotionally, they still think of the account as theirs. After all, maybe you earned the money. Maybe you deposited every penny. Maybe the other person never contributed a dime. But under joint account law, that may not matter the way you think it does. If your co-owner owes money, whether from a lawsuit, a judgment, tax issues, or other debt, creditors may be able to go after funds in that shared account because the debtor's name is on it. Think about Patricia, a 67-year-old retired licensed practical nurse from Knoxville. After her husband died, her adult son suggested she add him to her checking account so he could help if she ever needed assistance paying bills. Patricia agreed. Into that account went her pension, her Social Security, and savings built over more than 3 decades of careful living. Then her son's business situation fell apart. A legal judgment was entered against him, and the creditor reached into the joint account Patricia had always thought of as her own. A garnishment was placed on $44,000. Patricia hadn't done anything reckless. She hadn't guaranteed anyone's loan. She hadn't signed up for a risky deal. Yet because her son was a joint owner, the account became exposed. By the time she tried to sort it out, the money had already been tied up. Challenging it legally took months. She eventually recovered some of the funds, but not all. That is the kind of situation people assume can't happen until it does. And it's not limited to private creditors. Federal tax authorities can also reach joint accounts in certain circumstances. In some places, other collection pathways may exist as well. The legal details vary by state, but the bigger point is the same. Once another name is on your account, that person's legal and financial trouble can widen the path to your money. There's another layer here that families often miss completely, and that's Medicaid planning. If you or your spouse later need Medicaid help for nursing home care or long-term care, your finances may be reviewed closely. That review often goes back several years. A joint account can create confusion because money in that account may be treated as belonging to both owners for eligibility and transfer review purposes, even if only one person was actually funding it. Families often add a child just to help, without realizing that the structure may complicate benefit planning later on. Then, at the very moment they need help most, they run into delays, penalties, or disqualification periods they never expected. So rule change number 2 is this. Your co-owner's liabilities may expose more of your balance than most people realize. And if you haven't checked recently, this is the moment to do it. Pull up your account summary, not from memory, not what you think is true, but the actual list of names on every shared account. Look carefully. Then ask yourself one simple question. Do I fully understand the current debt, legal, and tax situation of every person listed here with me. Because if the honest answer is no, you may be carrying more risk than you realize. Now, before we move to the third rule, I also want to mention something important. I spend a lot of time covering the deductions, exemptions, savings opportunities, and financial breaks many seniors already qualify for, but never claim. I put those resources together in one place, organized state by state and form by form, so you don't have to waste time digging through confusing government sites. It's called the Senior Exemption Playbook, and you'll find it in the first pinned comment below this video. It's there to make this stuff easier. Now let's get to rule change number 3, because this one is exactly why I wanted to make this video in the first place. Rule change number 3 is the expanded exploitation window. In simple terms, banks have adjusted internal monitoring and dispute practices around joint accounts in ways that can give bad situations more time to unfold before the other account owner can stop them. Here's why that matters. If a stranger hacks your account, the bank's fraud systems are built to look for that. If someone from another state logs in, if there's an unusual device, if spending patterns suddenly look bizarre, those systems may react quickly. But if a joint owner makes the withdrawal, from the bank's perspective, that transaction often appears authorized from the start because legally it is. That means unusual behavior by a co-owner may not trigger the same kind of alarm. By the time the other account holder realizes something is wrong, a substantial amount of money may already be gone. In the past, some disputes involving joint accounts could move into review relatively quickly, but newer account language and internal policies have created more gray areas because the bank can point to the simple fact that both people had legal access. In some cases, the dispute process can drag on for months. In others, banks may decline to reverse anything at all because the transaction came from someone whose name was officially on the account. That creates a dangerous gap between the first questionable withdrawal and the point where anyone can meaningfully intervene. And this doesn't only apply to clear-cut family betrayal. It also affects situations involving confusion, coercion, or cognitive decline. Take an older married couple who have shared the same checking account for decades. One spouse starts experiencing memory problems. Around the same time, a caller reaches out pretending to be from the bank's fraud department. The caller sounds convincing. Maybe the phone number looks legitimate. Maybe the voice sounds calm and official. They say the account is at risk and the money must be moved right away to a safe account. The spouse with memory difficulties, trying to protect the household, follows the instructions. By the time the other spouse finds out, a large transfer has already gone through. And because the person who approved it was an authorized owner, the bank may have had no automatic reason to stop it in real time. This is where modern scams become especially dangerous. Caller ID can be spoofed. Voices can be mimicked. Fraud tactics are more polished and more believable than they were even a few years ago. Combine that with a wider dispute window and the legal authority of a co-owner, and you have one of the most vulnerable setups many seniors will ever face. So those are the 3 changes: a survivorship clause that can bypass your will, broader exposure to a co-owner's creditors and liabilities, and a larger practical window for exploitation before the situation can be stopped or untangled. So what do you do about it? Here are 5 steps to start this week. First, ask your bank for the current account agreement for every joint account you have. Not the version you remember signing years ago, not the one you assume is still in effect. Ask for the current agreement in writing. Then read the section covering ownership and survivorship. That's the language that matters most. Second, compare that language to your estate plan. If you have a will, put the 2 side by side. If possible, review them with an estate attorney. At the very least, contact legal aid or look up a qualified estate lawyer through your state bar association. Many families discover at this point that their bank account setup does not match what they intended at all. One short appointment can prevent years of confusion and conflict later. Third, ask whether a durable power of attorney or a payable-on-death designation would serve your goals better than a joint account. A durable power of attorney can allow a trusted child or relative to handle banking for you if needed, without making them a legal owner of your money. That means they can help, but the funds are still yours, protected from their personal creditors and distributed according to your wishes after your death. A payable-on-death designation can also solve a major part of the problem. It allows the account to pass directly to a named beneficiary after your death, often without probate, while giving that person no ownership or access while you're alive. That distinction matters. They receive the money later, but they cannot drain it now, misuse it, or expose it to their own lawsuits, tax trouble, or debt while you're still here. Fourth, consider using a buffer account. If you truly need a shared account for convenience, keep only a limited amount there, enough for perhaps 30 to 60 days of normal expenses. Then keep your main savings in an individual account, ideally with a transfer-on-death or payable-on-death designation in place. That way, the helper still has access where needed, but your larger reserves are better insulated. You separate convenience from vulnerability. Fifth, look up your state's garnishment and exemption rules. In some states, certain types of deposits, such as Social Security or pension funds, may have protections, even if they are sitting in a joint account. But those protections are much easier to use if you understand them before a problem arises. Waiting until after a levy or garnishment begins can put you at a serious disadvantage. There's also one additional safeguard worth asking your bank about: a trusted contact designation. This is not a co-owner. It does not give someone access to your money. It simply gives the bank permission to contact a person you trust if they notice suspicious activity or signs that something may be wrong. It's an extra layer of protection that can help catch trouble early without changing ownership at all. And finally, there is one habit that may matter more than people realize. Check your statements every month. Not every few months, not once a year, every single month. Banks can catch some suspicious activity, but they cannot always tell the difference between a normal authorized withdrawal and the early stages of a serious problem, especially when the transaction comes from someone who is legally allowed to use the account. You can. You know what should be coming in. You know what your usual bills look like. You know whether something feels off. And often, spotting a problem early is the difference between fixing it and losing the chance entirely. That monthly review takes only a few minutes, costs nothing, and catches problems that no policy, no app, and no automated alert can catch as reliably as an attentive account holder. So let me leave you with this. That joint account you opened years ago for convenience may no longer carry the same risks you assumed it did back then. The rules around survivorship can override your will. A co-owner's creditors may have a wider path to the money than you realize. And banks may not move quickly enough to protect you when the person making the withdrawal is already authorized to do it. You likely never signed up for those risks knowingly. You probably never got a warning you truly noticed. And if a problem comes, it will not wait for a good time. Take the 5 steps this week before timing is chosen for you by a crisis, a creditor, or a mistake that can't be undone.